Hello, my name is Raymond MIllien. I'm an attorney at the PCT Law Group, and today I want to talk to you about patents. Patents are a grant by the U.S. federal government that entitles an owner to exclude others from making, using, selling, or importing into the United States an invention. And that invention can be a process, a machine, an article of manufacture, or a composition of matter. And as long as that process, machine, article of manufacture, or composition of matter is novel, non-obvious, and useful, then a patent can be issued. The term of a patent is 20 years from the filing date of the patent application. Now, there are two major types of patents. There are utility patents that cover how something works, and there are design patents that cover how things look. Now let's talk about utility patents for inventions that most of us are probably familiar with. There are two types of utility patent applications. The first is known as a provisional, and the second is known as a non-provisional. Now let's go through those two. A provisional patent application is sort of a temporary one-year patent application that doesn't need to meet the formal requirements of a quote-unquote real patent application, and is typically filed by those who are not sure if they're going to commercialize an invention and just want to get something on file to prove that they invented something on a certain date. A provisional patent application tends to be cheaper and faster to prepare for a patent attorney than a non-provisional quote-unquote regular patent application. Now, a provisional patent application is not examined by the U.S. Patent and Trademark Office. It will never become a U.S. patent. It is simply held by the Patent Office for 1 year until, if and when, the quote-unquote real patent application is filed. So you may have heard in the olden days people would invent something, write something, and they would put it in the mail and mail it to themselves to sort of prove the date that they came up with it. Well, rather than relying on that, the U.S. Patent and Trademark Office allows us to file provisional patent applications where we file that provisional patent with the Patent and Trademark Office, and they hold it for us for 1 year. In order to ever obtain an issued U.S. patent, the applicant must file the non-provisional patent application within 1 year of the actual filing date of the provisional patent. Obviously, the non-provisional patent application is a more involved process, a more expensive process from the point of view of the applicant. So why would anybody ever file a non-provisional patent application? Well, there are times where you're not sure if you want to commercialize the invention. Maybe you need that extra year to raise funds, to seek board members, to seek advisors, to see whether or not your invention is indeed able to be commercialized. So therefore, a lot of people file a provisional patent application as sort of a 1 year option on filing the quote-unquote non-provisional patent application. And here at PCT Law, our attorneys are available to assist you in determining whether you should file a non-provisional versus a provisional patent application and to counsel you throughout the process. Thank you.